Good morning, everyone. My name's Robert Hay. I'm the chair for this seminar and also one of the speakers. The topic is the use and abuse of caveats. Firstly, I'd like to thank Justice Croft for attending. He's on as a regular supporter of the Greens List seminars, well, the property law ones in any event. In fact, his honour often features in many of the cases that are discussed. So I will speak first, followed by Brett Harding. First, a little about Brett. Brett is a commercial barrister, albeit he has a heavy emphasis on property law in his practice. He's also a lecturer in property law in the Master of Laws program at Monash University, and he's written a number of articles concerning property law published in the Australian Property Law Journal, the Property Law Review and the Australian Law Journal. Secondly, a little about me. I'm Silk at the bar, practising mainly in property law. I'm the co-author of 3 property law texts, and right now I'll put it a plug for a new one coming out in December, 4th edition of Commercial Tenancy Law, written with Justice Croft and Luke Vergona, who's also on Green's List. Now, this seminar today will examine the fundamentals of caveats, the consequences for practitioners lodging improper caveats, what is a caveatable interest. Brett will talk about Queen's caveats. We'll also deal with how can a caveat be removed, what are compensation principles for the lodgement of a caveat without reasonable cause, and the effectiveness of no caveat clauses in contracts and agreements. Now, Professor Robinson, in his famous text, Transfer of Land in Victoria, described caveats as the most important part of the Transfer of Land Act, second only to those provisions which confer an indefeasible title and registration. Now, it's certainly true that caveats are the cause of most litigation. In fact, Brett's got many of them going at the moment. Why are they important? Well, they provide the only real means of protecting an equitable interest in a system that accords priority to registered interests. And of course, it's trite to say that a person must be claiming an estate or interest in land to lodge a caveat. I mean, that's made clear in section 89 of the Act. But the abuse of caveats is widespread, and they're commonly used as bargaining chips, particularly to delay developments, extort money, and in some cases outright harassment. I understand recently a judge has made an order that the registrar of titles is not to accept caveats from a particular person because they just lodge them willy-nilly. There's an excellent case which I'm about to deal with, which deals with a lot of the principles, and it's a great starting point for people interested in the law about caveats. It's a decision of Justice Dixon called Yamin and Mazloom. It's 2017 VSC 601. You'll see it in your paper. A reading of that will highlight many of the issues that we're going to discuss today. In that case, the plaintiff, Yamin, owned land in Werribee. The property was mortgaged. Yamin was in default of his payments, and the mortgagee took steps to enforce the security. So as to maximise the sale price, the plaintiff negotiated with the mortgagee to sell the property by private sale. The property was in a very poor state, and the plaintiff asked the first defendant, who I'll now call the caveator, at this point in time he hadn't lodged a caveat, to assist with cleaning up and preparing the property for sale. The caveator told the plaintiff that the job was a substantial job, one that he couldn't put a figure on, a money figure, and the work would be intensive. And he also said he wasn't prepared to do the work unless the plaintiff could assure him that he would pay him. It appears that they reached an agreement that the caveator would be paid out of the sale proceeds. The work took about 4 months, and shortly after the works were completed, the property was sold. A week later, that's a week after the sale, the caveator lodged a caveat claiming an implied, resulting or constructive trust over the property. Later correspondence with the caveator's solicitor revealed that the claims were based on the works the caveator had undertaken at the property, and the caveator was claiming about $45,000 in payments. Settlement of the property was scheduled to occur on the 11th of September of this year, but because of the caveat the Settlement fell through, and the following day the purchaser served a rescission notice on the plaintiff. The plaintiff then applied to the Supreme Court to have the caveat removed under Section 93 of the Transfer of Land Act. I'm sure you're all familiar with that. That section states that any person who's adversely affected by a caveat lodged over land may issue proceedings in the Supreme Court or the County Court for the removal of the caveat. That's a summary. And the court may make any orders as it thinks fit. So the court has a really wide discretion. Now, Justice Dixon provided a succinct summary of the principles to be applied. Firstly, he made the point, which is a well-known one, the court's power under Section 90 is discretionary. Now, that's the provision under which most caveats are removed. So, with it being discretionary, you have to persuade the court why the caveat should be removed. Now, secondly, and this is also well established, he made the point that Section 90, subsection 3, is in the nature of a summary procedure and analogous to the determination of interlocutory injunctions. So, you can obtain an order quickly and basically they'll run, and the tests are similar to an injunction. So it works like this. Once the owner of the land makes the application to remove the caveator then bears the onus of establishing that there's a serious question to be tried. You might recall that's the old injunction test. Serious question to be tried that it has an interest or a stake in land that it's claimed. Now, the caveator must show at least that there's some probability on the evidence before the court that they'll be found to have an equitable right or interest that's asserted in the caveat. And what the court does is examine the interest claimed, the relationship between the caveat and the interest claimed. That's the primary thing the court will be looking at. So if the caveator establishes a serious question to be tried, then the caveator has a further burden, and that is he or she's got to show that the balance of convenience favours the maintenance of the caveat until the trial of any hearing. In sorting out the balance of convenience, the court takes whichever course appears to carry the lowest risk of injustice. By that I mean, and I'm paraphrasing Justice Dixon here, means the court will make its decision on the basis that if it gets its decision wrong, that is the decision today, the day on which I'm making this decision, what consequence will it have at the hearing if I turn out to have been wrong? So, for example, what is the consequence if an order is made today that the caveat be removed and I turn out to be wrong? Or what are the consequences if I don't remove the caveat and it should have been removed? So the court will do a balancing exercise to see who's going to be worse off in that scenario, in those scenarios, and make the order accordingly. Obviously, there's a relationship between the serious question to be tried and the balance of convenience. The stronger the serious question to be tried, the less emphasis there is in examining the balance of convenience. So they're the fundamental principles, and they're well set out in Justice Dixon's judgment. Now here the caveator argued that he had a claim in quantum merit to be paid for the work, and quantum merit, as most of you would know, means a claim for reasonable value of the work performed. And he argued that his claim in quantum merit gave rise to a constructive trust over the land. And I respectfully say that's a rather bold claim to make in support of maintaining a caveat. Quantum merit is a subcategory of unjust enrichment, and it's a claim for money and doesn't give rise to a proprietary interest in the land. There were some arguments that were made, I should say, in defence of the caveator. Justice Dixon found the evidence disclosed no basis for the caveator to claim an entitlement in equity to the remedy of a constructive trust. And this is what he said, and this is what happens in many cases. It's unsurprising that the caveator wanted an assurance that he could be paid, but on his own evidence he did not ask for an interest as a beneficiary of any equity in the property. It was not led by the plaintiff to believe that any such interest was being granted to him if he performed the work. He did not ask for security. And His Honour went on to look at a practice that we have in Victoria, practice where caveats were lodged as an absolute prohibition on dealings with the land rather than a conditional prohibition. So there's no mention in this caveat about, being owed $45,000. if that had been mentioned, there might have been an arrangement made for $45,000 to be set aside to ensure that if he turned out to be incorrect, he could have been paid. His Honour referred to the leading case of Poroshenko, which is mentioned in your handout, the decision of Chief Justice Warren, which he held that a caveat may only be lodged in a form commensurate to the interest it is designed to protect. In other words, you can't go and claim an interest that is... You can't go and claim a protection that's beyond the interest you are trying to protect. It'd be nonsense for a lessee, for example, to claim an absolute prohibition because a lessee doesn't need an absolute prohibition. The vendor can always sell land. His Honour also referred to another leading case called Schmidt, which again, this is Chief Justice Warren. She said, it's apparent from the cases that come before this court that a practice has developed whereby caveators, presumably through their solicitors, immediately opt for an absolute prohibition on dealings with the land. Indeed, I believe this is the default position on the form. Further, it has been noted that the form provided by the Registrar of Titles does not reduce the problems caused by a lack of comprehensive administrative, judicial guidance or legislation on how to describe interest or estate or how to limit the prohibition expressed in the caveat. Now, that was a 2006 case, so the form has now changed. The old-style forms used to contain a section titled Grounds of Claim, where the caveators would need to state with sufficient particularity the interest they were claiming. So, for example, an equitable fee simple interest based on a contract for the sale of land, you might mention the date, the parties to the contract, so the person reading the caveat would know precisely what they're dealing with. Now, the new caveat forms have made it probably too easy. If you look at the website, you'll see a drop-down box where the caveator simply selects the claims category, and there are several of them. One's agreement/contract, there's another one headed certificates of title, another one headed charge, another one headed court/tribunal order, another one headed lease, another one mortgage, another one other, then there's statutory charge, another trust and settlement. So depending on the category, once you choose a category, then there's other headings. For example, implied, resulting or constructive trust. That appears under the trust settlement heading. Now, the use of this form has again made it very easy for caveators to simply pick an interest and not really having to properly articulate the interest that they have in the land or even consider it. Even now, you can put in a ground court order made under the Family Court Act. Now, I understand from family law barristers that there's, for many years, people have lodged caveats in family law proceedings. So people often just put in court order under the Family Law Act. Well, a court order is not a proprietary interest. Of course, if the claim's properly pleaded in the family court case, there might be a claim for a resulting trust, and you can properly lodge a caveat. If at the end of a trial a court awards a party a constructive trust, you can lodge a caveat. But a caveat at large, just referring to court proceedings, is not a caveatable interest. But the Titles Office does contain that option. Now, even the heading implied, resulting or constructive trust, that is not particularly helpful, and Justice Dixon criticised this in this Yasmin decision. He said this: the expression used in the caveat, and of course this is based on the existing form, 2017 case. The expression used in the caveat is not simply constructive trust. The grounds refer, as I have noted, to an implied, resulting or constructive trust, which is not an uncommon phrase, despite the fact that the authorities make clear that there are real and distinct differences between each form of trust identified in the phrase. The use of the phrase is usually evidence of a degree of loose thinking, but that's what the form actually leads you into. Now, of course, this is not a talk about trusts, but an implied trust is a trust arising by operation of law where there's no express intention to create a trust. The court presumes the parties intend to create a trust. A resulting trust arises where a person purchases real estate or personal property and arranges for the title to be in someone else's name. And they arise at the time the contribution's made. And of course, a constructive trust arises again by operation of law irrespective of the party's intentions, and that is that can be an interest in property. So the new forms have not really solved the issue of imprecise descriptions. Justice Dixon also dealt with a problem that often emerges. He's critical of the way in which caveats are used as bargaining chips, and often at the hearing applications are made to amend the caveat. You know, improperly worded caveats that parties seek to fix up. The law in this area is generally that you can't amend a caveat to claim a new interest. You can generally amend a caveat to claim to better describe the interests that you're claiming. But in exercising the discretion under Section 93, Section 90, subsection 3 made 3 points. First, whereas would be needed here, an amendment seeks not just to amend the grounds of claim or the scope of protection, but also seeks to amend the interest claimed. It effectively results in the substitution of a different caveatable interest to that advanced by the caveator, and will not usually be permitted, which is the point I just made. To substitute a claim pursuant to a charge or equitable lien arising under an agreement that prohibited dealings other than to recognise the entitlement to debts is a new caveat. Substantially, the whole caveat has to be amended. In reality, it would be withdrawn and replaced. So he's saying there you shouldn't do it, and the courts would generally not allow it. Interestingly, in this case, the caveator didn't actually apply to come up with an alternative claim. That was a claim that Justice Dixon divined or ascertained from the evidence that could have been made. Secondly, the circumstances in which the error in the description of the grounds of claim or the interest claim made are relevant. This is not a case where the caveat has been prepared by an unrepresented person. So we had a solicitor here. The caveat was prepared and lodged by a solicitor who certified that he'd taken reasonable steps to verify the identity of the caveator and had retained the evidence supporting the claim. This is significant for some of the things we're going to talk about later about solicitors' liability. The third matter affecting the discretion is that the court should not readily act in a way which might encourage the belief that caveats can be imprecisely formulated and then fixed up later. Caveats act as an interlocutory injunction. The courts have recognised wrongly formulated caveats should not easily be tolerated. This caveat bears every indication of being imprecisely formulated with the possibility that it might be fixed up later. The court has on a number of occasions commented that caveats should not be used as bargaining chips. That's what he found happened here, effectively. Courts are not likely to allow amendments to caveats that describe a new interest. Now, in his final paragraph of his judgment, he reserved liberty to the plaintiffs to make an application for a personal cost order against the caveator's solicitors. And this leads to the second part of what I'm going to talk about is implications for practitioners in lodging improper caveats. There's a growing number of cases where cost orders have been made directly against practitioners who have improperly lodged caveats, and in at least one case, the referral of a solicitor to the Legal Services Board. The first case I'm going to mention is a case called Pearl Lingerie Australia Proprietary Limited and TGY, where the caveator again claimed an implied resulting or constructive trust based on a joint venture agreement. Now, yes. Here the plaintiff applied against the defendant and its solicitors personally for costs. The plaintiff claimed that in preparing and lodging the caveat, the defendant's solicitors had failed to properly investigate whether the defendant had adequate grounds to lodge and maintain the caveat. The relevant documents should have been reviewed at the time of preparing and lodging the caveat. And of course, had they been reviewed, a competent solicitor would have formed the view that the documents didn't disclose a basis for the lodging of the caveat. And the problem here was exacerbated because the plaintiff had written to the defendant's solicitors saying, and this is on several occasions, saying their client had no interest in the land. And at a previous hearing, another judge had actually warned them of the same thing. Now, Justice Croft, who I said is often involved in these cases, made an indemnity order against the solicitors and also referred the matter to the Victorian Legal Services Commission and here I'll quote him, because of the nature and seriousness of my findings. And he requested that the Commissioner take further action as considered appropriate. Now, that solicitor was ultimately prosecuted by the Legal Services Board and pleaded guilty to 3 charges of professional misconduct. In that hearing before Senior Member Smithers, the Senior Member said this: in summary, solicitors have a duty to satisfy themselves before lodging a caveat on behalf of a client that there is a proper basis for doing so. Clients may be very eager to restrict the ability of a party with whom they are in dispute to be able to deal with their land. But as the Chief Justice made clear in Perashenko, a caveat is not a bargaining chip. Solicitors must bear in mind that a contractual, equitable or statutory right against a caveatee is not enough. There must be a right which attaches to the property over which the caveat is lodged. Further, under the extent of prohibition on the form of caveat they lodge, solicitors must not state absolutely or only a lesser restriction on dealing with the land is justified. The tribunal went on to talk about general deterrence. Of more significance here is general deterrence. Solicitors need to be aware that if they breach their duties in relation to the lodgement of caveats, they are liable not only have to pay indemnity costs personally and to be found guilty of professional misconduct, they are also at risk of having their practising certificates suspended or cancelled. There's another case I'll briefly mention, that's Legal Services Commissioner in Makeda. In that case, a practitioner lodged a caveat on the property of her client's husband, a security for her costs. It's outrageous, really. Despite a number of requests, the practitioner refused to withdraw the caveat, and following a contested hearing, the tribunal accepted that there was no basis to lodge the caveat. The tribunal said this, that it was strongly arguable that when viewed in total, the practitioner's conduct could amount to professional misconduct, and the practitioner's conduct in relation to these charges falls towards the up end of unsatisfactory professional conduct. There's been 2 further cases also where cost orders have been made against solicitors. I won't go into them. You'll have ascertained the basis on which they might have been made already from what I've said. So the best way to avoid cost orders and disciplinary consequences is to ensure, as best as you can, that your client has a caveatable interest. On that point, I'll stop and Brett will continue. Brett will be dealing with the issue of what is a caveatable interest.
Thank you, Robert. The central issue when it comes to caveats is what is a caveatable interest. It's the most contested, contentious and litigated issue in this area. The key to lodging a caveat that will withstand scrutiny, or depending on which side you're on, having it removed, is the interest you claim. In the case of Crampton and French, Justice Harper held that any equitable interest in land is capable of supporting a caveat. This conclusion has been universally accepted as correct. Furthermore, there is now a body of authority which states that an interest based on a constructive trust can constitute an estate or interest claimed under a caveat. However, it's arguable that these authorities miss a crucial point. There's been a long-standing debate in Australia about whether a constructive trust is institutional or remedial. If a constructive trust is considered institutional, then the trust arises when the elements of the trust are made out. That means that a person will have a presently existing equitable interest in the land. If a constructive trust is considered remedial, then the trust arises at the time of court order. That means that a person has no interest in the land until a court orders that such an interest exists. The distinction is an important one. To lodge a caveat, you must have a proprietary interest in the land. If the constructive trust you seek is remedial, then you simply do not have an interest in the land unless a court declares so. This could be years after the cause of action accrued. In the well-known case of Mashinsky and Dodds, Justice Dean suggested that a constructive trust was remedial in nature. His Honour held that, viewed in its modern context, the constructive trust can properly be described as a remedial institution which equity imposes regardless of the actual or presumed agreement or intention of the parties. In particular, where competing common law or equitable claims are or may be involved, a declaration of constructive trust by way of remedy can properly be so framed that the consequences of its imposition are operative only from the date of judgment or formal court order. This position is supported as well in Jacob's Laws of Australia, Laws of Trusts in Australia, which I won't read out to you, but the proposition is confirmed there as well. The problem is that there are cases which state that constructive trusts are likely remedial, and there are cases which simply state that a constructive trust can be caveated. To the best of our knowledge, these cases have not intersected to provide an answer to the question, if a constructive trust is remedial, can it be caveated? In our view, this will also be an important question going ahead, since we've seen in so many of the cases the phrase implied resulting constructive trust seems to be the one favoured. We've put together a table in your handout which summarises those interests which are capable of supporting a caveat, those interests which are not, and some in the maybe category. I want to focus on some of the more contentious ones in there. The first one you'll note in the second column, which is interests which cannot be caveated, is that you cannot lodge a caveat over your own fee simple interest. That's supported by a case called Swanson Mortgages, and what that means is if you own a property, you cannot lodge a caveat over your own property. Now, surprisingly, that comes up a lot, and in the case, Justice Brooking, I believe, was in that case, who said that what you need to show is a separate and distinct interest in the land. And we'll come back to that a bit later, but that really makes it impossible for you to lodge a caveat over your own title. We also have beneficial interests under trusts, which is in the first category, which can be caveated. Now, I've noted there as well a case of Schmidt. This is a case which deals specifically with the case of unit trusts. This case makes it clear that despite an interest in a unit trust being an equitable interest, you still have to go and construe the trust deed itself to see whether or not a caveat can be lodged. The reason for that really is that the property in a unit trust belongs to everyone who has a beneficial interest in it, not one particular person who should be able to lodge a caveat. The last one I'll speak about here is an option to purchase. This is a particularly important one in commercial dealings and is capable of forming the basis of a caveatable interest. Importantly, I want to note in the maybe category, and these are caveats purportedly lodged to protect against a fraudulent dealing in the land. Now, the equity to set aside a fraudulent transaction is a mere equity which cannot be caveated, and that's the general view. There is an opposing view which I've footnoted there for you, which is the decision of Justice Taylor, but that means if there is some fraud on foot, a caveat can't be lodged to protect someone's interest in the land. I want to move now to a discussion on how a caveat can be removed. There are three principal ways in which a caveat can be removed. The cheapest and easiest way is simply to write to the caveator and say, please remove your caveat. It's always helpful to point out some authority that shows that they have no interest in the land. The second way is to apply to the Registrar of Titles to have the caveat removed. Now, in our experience, that the Registrar does not readily do that, and there's an increased feeling amongst practitioners that they don't want to be the ones signing up the certificate that says there's no interest, and that's quite understandable from a risk-based analysis. If you're certifying that someone has no interest and they turn out to have that interest, you yourself could be in hot water. The last and unfortunately most common way is to apply to the Supreme or County Courts. Now, I thought I'd outline practically how that works, at least in the Supreme Court. An application is made to the Associate Judge's Practice Court, which you accompany with your originating motion, your summons and affidavit in support. The court can then give you a hearing date, and it can happen relatively quickly. A lot of these caveat removal cases are time sensitive, usually because the registered proprietor of the land has an incoming purchaser. They've got a contract of sale on foot, it's about to settle in a few weeks, and it's important that the caveat be removed. The court has developed a very useful suggestion and mechanism to deal with these situations, and that is to ask the caveator what sum of money would they like for their interest claimed. The court can then make an order that that money be placed into a solicitor's trust account or paid into court. The caveat's removed, and effectively you can have the argument about the caveat later once the property is settled. That's a very pragmatic way to deal with it, and often it means that money from the sale is then released and we can have a proper argument with some funds. Now, unsurprisingly, many practitioners don't want to do that because you have the caveator over the registered proprietor over a barrel at that point because they're about to settle in 2 weeks. But as we've pointed out, the courts have indicated that caveats are not a bargaining chip, and if you go down that line, you're likely to get a personal cost order against you. The test, as Robert has set out, comes from the case of Poroshenko, and the court has effectively there applied the test for an interlocutory injunction from ABC and O'Neill. The important point is, once you, as the registered proprietor, inevitably apply to the court to have the caveat removed, the onus is then upon the caveator to prove they have the interest, which is very helpful. If you apply to the registrar, the onus is really on you to satisfy them that there is no interest being claimed. I want to move now to the issue of compensation for the lodgement of improper caveats. This is an often forgotten about section, and effectively what it says is a person who lodges a caveat without reasonable cause is liable for compensation to the owner of the land where that improper caveat has caused them loss. I've just set out a very simple example here. A sells their property to B for $1.5 million. Settlement is due in 3 months. However, 2.5 months later, C lodges a caveat over the property. The caveat is based on a judgment debt. C refuses to move the caveat, and consequently, the sale with B falls over. A later sale only nets $1.2 million. Section 118 allows A to sue C for the shortfall of $300,000. C's improper caveat, lodged without reasonable cause, directly caused A's loss. The seminal case on compensation under that provision in Victoria is the case of Commonwealth Bank of Australia and Barristers, in which Justice Hayne set out the principles as follows. First, the onus is on the claimant to show that the caveator acted without reasonable cause. Second, it's not enough for the claimant to show that the caveator did not in fact have a caveatable interest. Third, the foundation for reasonable cause will often be not the possession of a caveatable interest, but an honest belief on reasonable grounds. And fourth, an ulterior motive will demonstrate a lack of reasonable cause, even if the caveator had an honest belief. I want to discuss now a recent case from the New South Wales Court of Appeal called New Galaxy Investments and Thompson. This case discussed the New South Wales equivalent to Section 118, which is 74 capital P. The facts of this case are long and complex, but I'll attempt to distill the relevant principles for our purposes. In that case, Justices Baston and Gleeson held that the phrase "without reasonable cause" engages both a subjective element, which is a belief on the part of the caveator, and an objective element, the existence of reasonable grounds for the belief. The court said that nothing is added to the word belief by calling it actual belief. Their Honours found that, in general, a caveator will be able to establish reasonable grounds for lodging the caveat if he or she received professional legal advice before lodging the caveat. However, they held that there may be circumstances in which a party, believing that it is entitled to lodge a caveat, cannot establish reasonable cause merely on the basis that it had legal advice to that effect. For example, it may not be able to rely upon such advice if it failed to disclose to its lawyers a material fact which might have led to different advice being given. Justice Sackville, in dissent, said that legal advice that a caveator was entitled to lodge a caveat may be of considerable significance in determining whether the claimant has established that the caveat was lodged without reasonable cause. Even if the legal advice is incorrect, the fact that the caveator acted on the advice when lodging the caveat may preclude the claimant from establishing that the caveator lacked reasonable grounds for believing they're entitled to lodge the caveat. On the other hand, it has been said that a caveator does not necessarily absolve himself or herself of responsibility by taking legal advice. Further to what Robert discussed about the registrar's caveat form, it may be argued that a caveat can establish reasonable cause by simply relying on that form, which allowed them to claim the interest, even if it's contrary to case law. This may give rise to some sort of bureaucratic immunity. The next section I want to talk about is what's headed Queen's Caveats. This is an often forgotten section, and I will set the scene for you. Unfortunately, fraud cases are much more common than we might think. The pervasiveness of fraudulent dealings in land, particularly in mortgage transactions, has been increasing since the mid-90s. The nature of the fraud is typically simple and unsophisticated. It's usually perpetrated by someone who has a relationship with the registered proprietor of the land, such as a spouse, family member, friend, or trusted associate. The fraudster abuses this relationship to access the certificate of title, and then inevitably approaches a lending institution pretending to be the registered proprietor, or ostensibly acting on their behalf. They then forge the signature of the registered proprietor on the loan agreement, mortgage instrument, and associated documentation. The lending institution registers a mortgage as security over the property and advances the loan monies to the fraudster under the impression that they are the registered proprietor. The fraudster absconds, and when the default occurs, the mortgagee moves to exercise its power of sale. The fraud is then exposed. However, as in some cases, the registered proprietor discovers the fraud before the fraudster has become the registered proprietor or the bank has registered their mortgage. They have two options at this point: lodge a caveat to stop any transaction concerning the land, or seek an injunction from the court preventing registration. Obviously, the quickest and cheapest way to deal with this is to lodge a caveat. However, the question must be what proprietary interest in the land is being claimed. In the case of Swanson Mortgage, which I referred to earlier, it made clear that in Victoria, a registered proprietor of land cannot caveat their own interest. The court said that the registered proprietor must have a separate and distinct interest in the land. Now, that ignores an obvious problem caused by the doctrine of merger. For example, if you have a lease over a property and you then purchase the property from the landlord, you no longer have a lease. Your lease merges into your fee simple or your ownership interest, because that is the higher interest and the only one that you need. You don't need a lease over your own property. Therefore, it is near impossible that a registered proprietor of land will ever have a separate and distinct interest on which to lodge a caveat. The only real option, therefore, is to go to court and seek an injunction preventing the registration. Now, this is obviously timely. You need to get your material together and get a date before the practice court, however quickly you can get on. However, there's one other avenue at this point which can be used, and that is the lodgement of a Queen's caveat. This arises under Section 106 of the Transfer of Land Act, and it gives the power to the registrar to lodge a caveat on behalf of the Crown, and relevantly the last part of that section I've extracted there, for the prevention of any fraud or improper dealing. Robinson states that this gives the registrar the power to lodge a Queen's caveat to prevent improper dealings and to protect the interests of those people whose interests are incapable of substantive registration or indeed pending registration. While the power to do an act implies a complementary power to undo, it must be recognised that there are difficulties in establishing that there was no improper dealing or no fraud. Once fraud is alleged, the registrar may be reluctant to withdraw the Queen's caveat, and the property might be tied up needlessly. This may seem like an easy fix, however, it too poses problems. It takes time to write to the registrar, request that they lodge a caveat, and wait for a response, by which time the inconsistent dealing may have been lodged already. However, where time is not as much of an issue, this can be a good option. I have to say, from my experience, I did apply for one of these recently in a case, and the registrar wrote back saying, "We see that you have a case, however, what we'll do is refuse your application for a Queen's caveat, but closely scrutinise any dealings on this property." Now, that's better than nothing, but it doesn't provide much comfort to the person who's trying to lodge a caveat that inconsistent dealings will be scrutinised. The next point I want to deal with is no caveat clauses. Now, these are very common in development cases. By no caveat clauses, I mean a term in a contract of sale that says the purchaser promises that they will not lodge a caveat over the land. Now, the intention behind that is clear. In a large development of, say, 100 lots in a city apartment block, one purchaser shouldn't be able to hold up registration of all the other purchasers by lodging a caveat over the entire building. However, in the case developments, the intention is only one thing to keep in mind. In New Zealand, it's been held that these no caveat clauses are not against public policy because there might be sound commercial reasons for it. However, in Australia, it seems that these no caveat clauses do not deprive a person of a statutory right to lodge a caveat. However, if your contract of sale does include a provision that says you won't lodge a caveat, you will be in breach of contract and there may be a damages claim against you, but it does not stop you from lodging a caveat. It is open to a court to order that the caveat lodged in breach of contract may be maintained or extended. We want to leave you on a practical note, and I have to say Robert and I don't know much about the new PEXA system because we prefer to look at old cases instead. But I believe that on the 1st of December, some significant changes are being implemented with respect to the lodgement and withdrawal of caveats. From this date, all caveats and withdrawals will need to be completed and lodged through the PEXA system, and the Titles Office will no longer accept paper transactions. To use the PEXA system, you need to be a subscriber, and these are generally limited to solicitors, conveyancers, and banks who are registered members. This move will mean that members of the public can no longer lodge caveats. Now, this will no doubt reduce the number of dodgy caveats out there, but given the cases we've discussed, the impetus is really on practitioners to tighten up their practices as well. To summarise what we've discussed today, the first thing to keep in mind is come back to the primary question. Is what I'm claiming an interest in land? That's the starting point, because there are still many claims for debts out there. Consult the table in these notes. Have a look in a textbook or contact one of us. Our rates are very reasonable. Remember that caveats are not a bargaining chip, and if you try to use them as such, I'll be sure to get a personal cost order against you. And practitioners who misuse caveats can get themselves into very hot water. They may be liable for personal cost orders and disciplinary action. Thank you very much for coming, and we would love to answer your questions.
I might start the ball rolling. You mentioned you talked about section 118 of the TLA, and that talks about that's dealing with compensation where a caveat's lodged without reasonable cause. A common issue, though, is what happens where a caveat is maintained without reasonable cause. In other words, there might have been reasonable cause at the time it's lodged. What's your view about that?
I would think that if it comes to the attention of the person who lodged it, that circumstances have changed, they'd have to remove the caveat. Now, one issue that arises a lot, and there's a range of litigation on this in the Supreme Court from cases of Basiliou, where caveats were lodged over a range of properties that there was now a trustee in bankruptcy who had taken possession of it because Mr. Basiliou had gone bankrupt. When that had happened and the property was then sold by the trustee to someone new, those caveats had to go because he no longer had an interest in the land. That didn't stop him maintaining them anyway, but that's what should have happened in that case. When the circumstances changed, the caveat should have been removed.
Do you know of any cases that actually say have actually determined what's meant given that the section only refers to lodging without reasonable cause? I'm talking about the compensation provision.
No, I don't.
Right. Are there any questions?
This is from a self-interest as a practitioner.
Are you asking for a friend?
Now, in family law, we often lodge caveats at the commencement, often after the very first conference, to protect the interests of the party who hasn't got their name on the title of the other property of the other party. Are you suggesting, Robert, I just want to clarify, are you suggesting that we should only do that in concert with proceedings that are on foot with the court where we've pleaded it in our initiating application? Or can it be separate? Like, not all matters go to litigation or are not issued. Sometimes you do lodge a constructive trust arising from the breakdown of marriage and it goes ahead and all resolves beautifully in due course. But I just want to clarify what your point was. Are you saying it's better supported?
If you believe, as a solicitor, that there is a case for a constructive trust, then you can go ahead and lodge your caveat. Now, Brett's raised the issue about the difference between remedial and constructive and institutional constructive trusts. Now, that doesn't seem to have really emerged in the caveat cases. So, if you strongly believe that there's a constructive trust argument that's seriously available, then I think you should go ahead and lodge your caveat. The point that I was making is just to say family court order or something is meaningless, really. It doesn't show any proprietary interest in land. But if you actually have a basis to lodge a caveat on the basis for serious claims, there is a constructive trust, and you do have a basis to lodge.
But really what it means, you need to sit down with the elements of a constructive trust and satisfy yourself that your client has one. It's not sufficient to simply say they may have an interest in the property or I'm trying to protect their interests by lodging a caveat. Anything else? Yeah.
What's the situation where there's a change of solicitors? There's an initial solicitor may lodge a caveat. Circumstances happen down the track, whether on a property transaction there may be a rescission notice or there may be facts that come out that may mean that original caveat lodged may not stand up. And that original solicitor is not the solicitor at a later date, and there's a new solicitor. Now, what's the position? And you're talking about liability and compensation, but what's the position of the first solicitor, and also the position of the second solicitor? When we're acting as agents for the caveator.
Well, the first solicitor, provided he or she had a reasonable cause to be involved with the lodging should be fine. I mean, they've got no control once they've done that. There still might be a question whether there was a proper basis for lodging them in the first place. The second one is more... the second person probably it's in a more difficult situation because they weren't responsible for lodging the caveat. And I've just raised the compensation point too, you might recall here. It's not clear that a person can get compensation for where a caveat's wrongfully maintained, but I would think that the solicitor who's responsible for the maintaining of the caveat, when it's clear there's no basis for maintaining the caveat, could still get in trouble, for personal trouble.
I would think that as soon as it comes to your attention that there is no caveatable interest, you have to advise the client to remove it. And if they don't want to, you might have to stop acting for them or give them that advice in writing, because the first solicitor might have lodged a property, but if circumstances change, it's the client who's ultimately liable for the compensation that's ordered by the court. The solicitor will only get into trouble themselves if they know that the caveat should not be lodged and pressed ahead anyway.
I was involved with one recently where we probably had two potential caveatable interests in our pleadings, but the case changed completely. So, in fact, we withdrew one claim that supported a purchaser's lien and turned it into a case about the purchaser being entitled to recover instalments that had been paid on the basis of a failure of consideration. Now, in that case, we had extensive discussions with solicitors about the fact we had to withdraw the first caveat. It would be most improper to maintain the first caveat when we weren't really pursuing that proceeding anymore. So we did the solicitor withdrew the first caveat and lodged a new caveat claiming a completely different interest based on a new cause of action. And that's the way I think it should be done.
So in that circumstance, it's reasonable for the second solicitor who wasn't party to the first caveat to effectively start afresh and either, for example, disown any responsibility for the first caveat and just because it is a difficult situation when there's a time period involved for the second.
Well, of course, it's difficult, but I mean, the issue will be if the registered proprietor has been saying and is writing letters to the new solicitor saying your client has no caveatable interest, then the new solicitor has to really do something about it and say to the client, look, they're right, I think they're right, and you should now withdraw your caveat. I mean, as you've seen, the courts are getting really tough on this, so the solicitors have to be very careful.
Another question?
Yes, Robert or Brett, in terms of what you reference as a court order, what exactly are you talking about? A court order of the family court. Often we have orders permitting the lodgement of caveat. If there is no caveatable interest,
well,
does
that's a separate issue. So if the court has said, what we mean by court order, if you have a court order saying, come back next week for directions and you lodge a caveat on the basis of a court order, that's improper. And I would say that if a court says you can lodge a caveat without finding that there's a proprietary interest, that's probably also problematic. But if after a hearing a court says, I declare that the plaintiff has a constructive trust over this piece of land, absolutely you can lodge a caveat. But the basis of that caveat is for constructive trust over land, not court order.
Yeah, but that's the problem we have with the family court, because albeit there may be a separate entitlement by virtue of a trust, that's not the basis on which we get orders in the family court. It's a statutory
I understand that, and the issue is that everyone practicing in that area has a way of doing it. If this were to come into perhaps another court, that caveat would be removed, or that there would be an issue with that, because it's, strictly speaking, it is not a proprietary interest, and that's what the Act says you have to have.
And Professor Butt, in his leading text land law, just says straight out, the court order it's not a caveatable interest.
What about if it was a caveat by consent, even though there's no proprietary interest?
Still not a caveatable.
It's not a proprietary interest.
Yeah. So we've really got a problem in this state.
Yes, we do.
Okay, thank you.
I've just got a bankruptcy scenario.
You're not seeking advice, are you?
A scenario in bankruptcy where the person's gone bankrupt and they're an executor of the will and the one-third beneficiary. They're now bankrupt, and in bankruptcy, the trustee wishes to lodge a caveat in respect of that person's interest under the will. And the difficulty is there's only the right to the due administration of the will, and I'm not sure if there is a caveatable interest. Would you have any thoughts on that?
I understand there's often you'll look at the grounds and it'll say trustee in bankruptcy. Now, you must come back to the first question. What's your interest in the land? And it doesn't sound like there is one. If the trustee in bankruptcy has possession or is vested with a property because of that position, they holding it as a trustee, they're not holding it, they don't have a beneficial interest, you can't claim an equitable interest in the land. So I don't think that there is one, unless we can point to an interest in the land that the trustee has, apart from being a trustee. There was another question here.
I was just wondering if you're aware of any cases where a claim for compensation for lodging a caveat without reasonable cause under section 118 has been brought as a solicitor. So I just noticed that it says any person lodging. Say, for instance, if a solicitor was lodging on behalf of a child whose parents are deceased and an uncle's property is left to the uncle in the will or something like that.
I can't recall now, and I wouldn't want to say the facts of the case are wrong since the judge is here, but I think in the Pearl Lingerie case, there was two parties to that where compensation claims were made, and one was a solicitor and one was a party, but that's the only case I know where there might have been an intertwining of the two compensation claims.
There is a case that is currently before the court where that sort of an order has been sought against a solicitor. I'm from the Legal Practitioners Liability Committee, so we're running that case on behalf of the practitioner. In our view, the law in Victoria is just not settled on that question. There's New Zealand authority that says a solicitor is a person who lodges under a similarly worded section, but in other jurisdictions in Australia, the answer has been that no, it's only the caveator that's covered, but it's not actually settled law in Victoria.
Thank you.
Brett, I've done plenty of caveat removals in the Supreme Court as a lot of other people. I've never done one in the county. What's your experience over there? Because I think there seems to be a prevailing view that just go to the Supreme and it's all powerful and you get some sort of better result. I suspect that's not really true, and the practical consideration is you've often got county court litigation and somewhere along the line there's a caveat involved, and then if you've got the caveat removal in the Supreme, it's harder to tie things all together, to make offers, to settle. Have you got a view on that? Any experience in the county?
I've not been in the county court. I've also done them all in the Supreme Court. And I think, quite simply, the Supreme Court has a very efficient and practical way of dealing with these. Almost all of them will go before Associate Justice Daly, who does these day in, day out. It's just a very streamlined process. So I've never had to go to the county court. But they do have power, that's all.
Thanks.
One thing I'm not sure about is what's going to happen with scrutinising caveats under the new PEXA system. If they're just put in online, I don't know if Jerome Colopy's here, he might from the Land Titles Office, he might better explain this. What sort of scrutiny will occur once you lodge your caveat online? Is Jerome here?
I'm here, Robert, but I suspect Jane Allen might be better placed to answer James.
So the caveats are accepted at face value by the registrar. So
Do we have a microphone at all?
Yes.
Oh.
They go through business rules, and they will be accepted if they find those business rules that we have.
So the impetus is really on the legal practitioner to do the right thing.
It is in paper.
Yeah.
And if we don't get supporting evidence in relation to caveats, we're not looking behind the caveat, we just look at the face
I would be interested to know how many caveats you get a day. I assume there would be many.
How many caveats we get a day? I don't know the answer to that. We get a lot of caveats.
Yeah, and it wouldn't be practical, I assume, then for people at the titles office to be scrutinising every caveat.
Well, under the law, we don't need to. If it's made out on the face of the caveat, but we don't accept any Australian. Just whilst I've got the microphone, I can make a clarification comment. From 1st of December, those rules apply only to lawyers and conveyancers and people who are already subscribers to PEXA. So individual, unrepresented parties will be able to lodge caveats.
I don't know if everyone could hear that.
Can I ask you to repeat that again, please, Rob?
Unrepresented parties from the 1st of December will still be able to lodge their own caveats. Yeah, that's basically by paper, yeah.
Thank you.
Another question here. Yes, my question relates to the severance of joint proprietorship and alienation to tenants in common and the ability to charge, an individual's ability to charge an interest in their land and then to lodge a caveat. Is there still, I believe there was a recent case, unfortunately I can't remember its correct name, it's Lawrence and Hanson and a railway organisation being interested in a mortgagee, I believe ANZ. Is there an ability to lodge a caveat on behalf of someone with an interest in that person's interest in land, so to speak?
I don't understand the question, I'm sorry.
Sorry. Someone severed their joint proprietorship in land, tenants in common. Their ability to charge their interest in that land and then to allow a caveat to be registered. The extent of prohibition, I believe, has a hurdle there, albeit absolutely, because absolutely impinges on the other tenant in common's interest in that land. Is there a way to overcome that?
Right, so if we're talking about a situation where you have joint tenants or joint proprietors, is that law and inequity?
Yes, yes.
And so if they become tenants in common, either of them are entitled to take out a mortgage over their share, and that's fine. So is your question then whether one party can lodge a caveat over the property to protect their half?
No, they may charge their interest in the land to another party.
Caveat and equitable mortgage.
Sorry, can you repeat that?
Someone can lodge, let's say one of those tenants in common gives a charge to another which has a caveatable interest. So can that... Yes, it can. Yes.
Okay, so the registrar says yes, yes. Sorry, it took me a while to get my mind around the question.
Sorry. So I've heard a lot about the dangers of caveats, perhaps. What do you think are some good alternatives?
To lodging a caveat?
Yeah. Like, for example, if you're seeking sort of an alternative dispute resolution rather than going to court, I know that's really a word that people don't like hearing. But, yeah, what's some good alternatives?
Going back to the start of what we discussed, caveats are really the only way to protect an equitable interest in land. And it's a perfectly good system. So we're not saying don't use it, we're just saying use it properly. Another way to do it is obviously get an injunction preventing registration, which is more costly. And the court might rightly say, why don't you just lodge a caveat if you have proper interest? And I think also, one case I was involved in where the solicitors had said, we give you an undertaking not to deal with this interest, or we'll put some money into a trust account and we can remove your caveat and we can argue about it later. The problem is they haven't actually drafted a mechanism to deal with the situation. What if they can't agree on what to do? That money's been sitting in that trust account for over a year now because there's no way to get it out. So it's all about figuring out what option works best, and if you have a proper interest, lodge your caveat.
And of course, often the whole issue about the caveat being there only arises when the registered proprietor wants to do something. There's often a sense of urgency, and if you're talking about negotiation, the person who lodges the caveat is often in a superior bargaining position if the vendor is under stress, or there's a development that's got to go ahead, or some permit's got to be granted. So the vendor can often feel that they're being blackmailed, or the owner can often feel they're being blackmailed. At least by getting the matter into court, it evens things up a bit. And I mean, there may be situations where a judge orders a mediation. I don't know, but that's perfectly possible.
Yeah.
position of wills and estates, you often have beneficiaries. In the position of wills and estates, you often have beneficiaries issuing caveats based on the sale of the property falling to the residue, and obviously that doesn't benefit any capital interest. But what is the position where a beneficiary is specifically being bequeathed the property in question?
They'd have an equitable interest in that property. The problem is often if you say, I leave all of my real and personal property to X, what does that mean? They don't actually have a specific interest in any property. There might be 5 properties, there might be a car, there might be lots of real personal property. But if you're actually given a particular property that can be identified, yeah, you do have an equitable interest in it.
Yeah. The reason I ask that is because you have some instances where the only asset in the estate is the property that's been specifically bequeathed, and then you have the issue of the executive trustee who may need to sell that property in order to satisfy and settle all the testamentary debts and liabilities. So then you potentially have a fight between the beneficiary and the trustee in that regard.
Yeah, you would have, because if that's the only asset and there's a lot of debts left, the trustee might need to sell. But at the same time, the will specifically gives someone a beneficial interest. I don't know the answer to that, but I expect that there would be a conflict there because you would have an equitable interest.
Hi there. I've practiced in New South Wales as well and have seen a lapsing notice. And my understanding of that is that if you have a caveat lodged, the registered proprietor can serve a lapsing notice, which essentially makes the caveat disappear in the statutory period's time. I think that's 21 days. And then it's for the caveator really to go to court and make good on their claim. So just to clarify, the system is quite different in Victoria. Does that?
It's the same.
It's the
so
same.
Once an inconsistent dealing is lodged on a property, that pings off because it can't stick because of the caveat. A notice is then sent to the registered proprietor, and you then have 30 days to commence proceedings, or the caveat will lapse. So it's the same system here.
Same system.
Well, I believe it's 30. It's not 21.
And is it called, sorry, what's it called in Victoria?
So, I don't know what it's called, but it's under Section 89A of the TLA.
89A.
Yeah. But to say that again is open to abuse because the caveator is normally required to commence a proceeding to justify the caveat. But there's quite a practice here in Victoria of not serving, of filing the proceedings and then not serving them. Now, if the registered proprietor becomes aware of the proceedings, as they normally would, they can of course then file a notice of appearance, and the fact that they weren't served won't really make any difference. But I've been in cases where the vendor actually didn't realise, the registered proprietor, didn't realise that the proceeding had been issued. I'm not sure why they weren't notified, and so that stood there for nearly 8 or 9 months before they twigged.
I've had a case exactly like that, where the owner of the land found out via the grapevine what had gone on. The solicitor went and did a litigation search at the Supreme Court, found the file in which they were a defendant, filed the notice of appearance to actually bring the matter on, because it was just sitting there for more than a year, I think. Which is, again, you have to serve your writ within a year now. Another question? Right.
All right, it's 10 to 9. I think we probably should finish there. Would you please thank Brett and Michael Green for